Adam, you also have some updates regarding the student loan forgiveness Supreme Court hearing. The first being President Biden's somewhat pessimistic comments after that hearing. What did he say? And tell us any details that you have.
So President Biden, in some of his first comments after the hearing, said that while he remains confident that the program itself is legal, he does not have a lot of confidence that the Supreme Court necessarily is going to agree with him. And that assessment makes sense to some extent because certainly when I was listening to the hearing, I heard a majority on the court express varying degrees of skepticism about whether or not the program was legal. That being said, it doesn't mean that the court is definitely going to rule against the Biden administration on this initiative. It really is, anyone's guess as to how the court will rule. Just like with the other lawsuit we discussed, there could be an issue of standing here for the parties, meaning that if the challengers are not able to demonstrate a sufficient concrete injury directly related to them and the challenged policy, then the court could rule in the administration's favor without necessarily even getting to the question about whether the program itself is legal. So that remains sort of an unanswerable question at this point. We'll have to see how the court rules.
Despite President Biden showing some pause here, his administration conceded that there really isn't a backup plan should they fail in the Supreme Court hearing. So, do you think there should be?
A lot of consumer advocates have argued that there should be a backup plan. A different federal law called the Higher Education Act contains a provision that does provide fairly sweeping authority to the education department to cancel federal student loan debt, sort of akin to the authority provided by the HEROES Act. Now, the administration is publicly stating that there is no backup plan. That could be a viable backup plan. The problem there is that unlike the HEROES Act, which the administration used to implement the current initiative, any new initiative or regulations under the Higher Education Act would have to go through a much longer process to establish the program. It could take 1 to 2 years for new regulations governing that new program to be drafted. That could, be beyond, President Biden's presidency if he runs for re-election and loses, and then borrowers would not receive relief for at least a year or two, or possibly not ever if the program never goes into effect. So we'll have to see. Obviously, the administration is hoping that the court will uphold the current program. If it doesn't, we'll have to see if the Higher Education Act comes into play.
Why would this administration publicly say there's no backup plan? Is that just a show of confidence?
I think it's partially a show of confidence. I think it also may be designed to buttress some of their arguments before the court that this is the effectively only and best way to implement the type of relief that they're seeking. If they say that there's another route, then in theory that could encourage 1 or 2 justices to strike this down and tell the administration to try again. There could be any number of reasons why they're doing that.
And the Education Department sent an email to borrowers after the hearing. Can you give us a sense of what was in that message?
The message was essentially trying to reassure millions of borrowers, look, we think that the program is legal. We're confident of the outcome here. So please just kind of sit tight. Payments will continue to be paused while this process plays out. I think the Education Department is basically trying to keep in touch with borrowers, trying to reassure them during this period of pretty significant uncertainty, given everything that's happening with the payment pause, as well as the student loan forgiveness program.
And a separate student loan forgiveness legal dispute was happening while everyone was paying attention to what was happening in the Supreme Court. But it resulted in some good news for borrowers. Are these two suits similar at all?
So there was an entirely separate suit that's been ongoing for years. It's currently called Sweet versus Cardona. It is entirely separate from the case before the Supreme Court and concerns a different program called the Borrower Defense to Repayment Program, which can provide student loan cancellation and other debt relief to borrowers who were defrauded by their school, such as through misrepresentations about key aspects of the educational program. So that case ended in a settlement that could result in $6 billion or more in student loan cancellation for up to 250,000 borrowers. That settlement relief was then put on hold due to a legal challenge to the validity of that settlement. So while all this was playing out at the Supreme Court about Biden's one-time cancellation plan, there was a separate battle playing out in the lower federal court about the Sweet versus Cardona settlement. But a judge recently issued a decision greenlighting that settlement relief to proceed. And so now hundreds of thousands of borrowers are receiving emails notifying them that they qualify for relief. And that relief will be provided on a rolling basis over the course of a year or so.
So borrowers focused on the Supreme Court shouldn't look at this as this is good news for borrowers. It could mean good news for us in the future regarding the Supreme Court case.
There are just so many programs out there. I think a lot of people are understandably focused on the Supreme Court case because it is sort of the biggest and the most high-profile initiative by the Biden administration to address student loan debt. But there are so many other programs out there that are unrelated to what's going on at the Supreme Court, including the Sweet versus Cardona settlement related to borrower defense to repayment. There was a new overhaul to revised pay-as-you-earn, an income-driven plan that was recently announced by the administration that may lower payments for millions of borrowers. The Education Department is still implementing the limited PSLF waiver for public service borrowers. They're in the process of rolling out the IDR account adjustment, another initiative that can result in loan forgiveness for many. So there's a lot going on when it comes to student loan debt. And while we definitely want to know what's going to happen with the Supreme Court case, there's a lot of other programs that borrowers should be aware of as well.
Adam, there certainly is a lot going on with student loan debt, and I hope you come back on and break it down as new updates come in. Adam Minsky, thank you so much.
Thank you. Happy to be here.